Thank you very much. My name's Philip Hundl. I have been practicing here. I know Randy and Ben talk about the years they've been here, and it's surprising when I look back and how long I've been here. So I've been here in Wharton County. I grew up here and have been practicing here for almost 20 years now. So I practiced in San Antonio and Houston for a while at a big firm. Went to University of Denver, actually. People always say, well, why'd you go to Denver? Well, why not? Denver's a pretty nice place, and everybody agrees. And so, interestingly, most most of my colleagues in law school did not leave Denver, of course, and they wanted to stay there, and they stayed there. But it's been a lot of fun practicing here in Wharton County, and what I was able to do and enjoy and appreciate is the breadth of practice that I had for a long time, from criminal, family, estate, probate, you name it. I was able to do it, and it was very unnerving at times because of all the things you had to learn and do in the criminal procedure and then jump over to civil procedure. And I always looked at kind of the more experienced and seasoned lawyers, and they seemed to have figured it out and specialized and focused on a particular area. And so I always thought, well, these guys seem like they figured it out. So over the years, what I've tried to do is whittle away at what I didn't want to do and try to find what I enjoyed doing. And finding what you enjoyed doing in the law sometimes is challenging. And it was one of those rare weekends. I won't say rare weekends, but preparing for something on Monday or working on a Sunday. And the time just went away, and I got into what people call flow. And I said, you need to pay attention to this because you seem to enjoy this a lot. And it was a land case. It was actually an eminent domain case. I do a lot of. So now what do? I do eminent domain, so condemnation cases for landowners, and land partitions. So probably 20% of my practice, it fluctuates, is land partitions. The rest is representing landowners with land in eminent domain cases. So land partitions, what surprised me was as I handled more and more land partition cases throughout Texas, number one, not many lawyers know how those cases work and procedurally, and also many judges aren't real familiar with it because how often do they get a land partition case? So at any one time, and right now, I probably have about a dozen land partition cases going, and all in different courts and at different stages. And so I'm going to try to hit the high points on a land partition case. Of course, when clients come in, one of the first things they ask is, well, what's this going to cost? It's like any case, it depends, right? I hate to give you that answer, but if we, and I always tell everyone, I have certain steps. These are steps I go through. First step is, yes, we send our proposal. There's 100 acres and there's 4 kids, and this is the shapes or the pieces, the piece that I want, and these are the pieces that you guys can have. And if everybody says okay, well, then that doesn't cost very much. You get a settlement agreement in place. It could be a simple letter. You go get a survey, prepare deeds, and you're done. Or it could go all the way through, and we'll talk about the different stages, but it could go all the way to, quote unquote, the end. And it could be a case that costs, the same 100 acres could cost, and it could be 100 acres or it could be 10 acres, and it could cost $100,000, $200,000. I know both judges here have had long drawn out, as attorneys and lawyers, long drawn out partition cases. And I think one of the longest land partition cases in Wharton County was something that George Willis was involved with, Doug Bellini and Collins, Randy Clapp was involved with. And I think that case, don't quote me, but plus 10 years, 12 years. All right, so let's just kind of jump right into this. And hopefully everyone can kind of see. But we're going to go over today, what are the statutes? Won't spend a lot of time on that. But you got to know which statutes you're under, the 23 or 23A, property code, right here. So, it used to be for the longest just partition code, section 23. You also have to pay attention to, there's some rules of civil procedure that also apply to partition, so you have to know that. It's just not entirely in the property code, but it used to just be property code 23. And then it looks like, I was looking back at the history, it looked like in 2017 is when 23A came about. And that's the, when you wonder, well, what's the difference or what's 23A? It's just the heirs property partition. So if 20% of the property or more is owned by heirs, people that are related, or they acquired it through, inheritance or from a relative, then it's 23A. And frankly, most partitions are going to fall under 23A, is what my experience has been. I've got one where literally my client has 80% and the other person, and they're not relatives, the other person has 20%, so it fits in the under the statute 23A. So know which statute you're under. And then what are the general steps and procedures? What I gave everyone, passed it out, is a real detailed steps, because I always like clients to know, where you're at in the process. I'll talk about a lot of anecdotal stuff, and I'll change the names and facts a little bit, but I was the third lawyer hired on a large partition that involved land in 3 different counties, and big groups of landowners, and that's kind of how people kind of go to particular groups and gravitate to, well, that's our family, and there's 5 in this group and 8 over in this group, and they really all thought it was almost over, and we weren't even at the first trial yet. And I had to remind them, you've got a long way to go, and then all of a sudden things, I'm going to say kind of magically, everyone got a lot closer and got it settled. But let's talk about, steps. You have a first trial, and that's the one where, and I think we'll go, these are the bullet points. So we're going to cover today the steps and procedures, ethics considerations when you have co-owners representing multiple people and you think they're all on the same page, appraisal, the proper methodologies, and preparing for and conducting a meaningful mediation. This is critical, and a lot of people don't do this the right way, I don't think, or they don't give the mediation a chance, and then documenting it and wrapping it up is critical. So let's jump into first, do you have all the necessary parties? I learned this I don't know the hard way or just the right way from Judge Eslenbaum. We had a partition of approximately, I think, 12 acres, and he kept saying, do you have all necessary parties? Do you have all necessary parties? And normally a client will come in and say, well, there's only 4 people. Well, in that case, it ultimately was 26 people. And so, and it was a challenge, frankly, just to determine who all the heirs were. What did that require? It required an heirship proceeding, multiple heirship proceedings and determinations. And one side basically said, no, there's 27 people. No, there's only 26. Well, there's this one, we'll call him Jeremy. Jeremy's out there. Jeremy's an heir. No, we don't think Jeremy's an heir. Well, yes, we do. Well, ultimately, we had a hearing to determine whether or not Jeremy was or wasn't an heir. And I think that was one of the rare times that occurred. Sure, you've got partitions where sometimes it's real cut and dry. You've got a deed. A lot of times the title's not as clear as you think it is, and so that in and of itself could take, and I think it probably took us about 18 months to 2 years to get all the necessary parties.
Do you have to go back to probate to do that determination?
You would do it within, I've done it within this proceeding, yeah. An heirship within this proceeding, yeah.
So when that is done, does it have the same effect as probate court?
Yeah. You'll have a judgment from the court determining certain heirs, yeah. So 23 original, the heirs partition 23A. And what are kind of some of the differences in the 23A? You've got a court-ordered appraisal, and then you've got a buyout process. The 23A came about because it was properties, I think, in the history said, in urban areas owned by minorities, a real small percentage interest. Maybe there was 50 owners of a real now expensive retail block, and some investor, call it what you will, savvy investor would come and buy 1% out, and then he would file a partition and convince a court to order it sold or have it sold, and then he would buy it on the back end for a cheaper amount. And so this was a way to protect the heir, so to speak. And so there is a provision that if you're seeking the court or asking the court to sell the property, then you actually may have your share bought out from you. So if you're not wanting it sold, if you're wanting it partitioned, 100 acres, I want my 20 acres, you're not going to be forced to sell it to someone else on the 23A unless you're asking the court, please sell the 100 acres and divide the money. Then you could be subject to being bought out. Steps and procedures. This is where it gets a little odd and weird, I guess. You have a first trial. That's when the court determines whether it can be partitioned in kind or not. And what does the law say? The law says the court's going to try to find a way to make it partitionable. In other words, and so what does that mean? When someone comes to me and says, we've got these 50 acres and there's 10 of us, and there's no way to divide it up, I'm going to say, I think the court's going to say it can be partitioned. Now, if there's a 1 acre and a house and there's 20 co-owners, I'm going to say, yeah, I think the court's going to say it cannot be partitioned and it's going to be sold. But courts in this case law that says, yeah, the courts are going to try to find that it can be partitioned. Yeah, I mean, literally, how are you going to divide the house between 20 people, right? So the best way, the court's going to say the only thing we can do is sell it, and he would order it sold. And we can get into how that would work, but I think there could be a lot of different ways it could work. But they would appoint a receiver, a temporary receiver. They would be like a realtor to sell it, and then the money would be divided, the net proceeds. What also happens at the first trial? And these are critical things that often get overlooked. Is you get whether the land is partitionable or not. Okay. Appointment of commissioners, no problem. That's pretty standard. Everybody knows that. But getting a surveyor appointed. Well, why would you need a surveyor appointed? Well, because it's like anything. Well, all the co-owners say, well, we all know it's 100 acres. Well, is it or is it not 100 acres? And so it's important to get a surveyor to actually survey the property and say, oh, guess what, folks? It's 98 acres. Or what you thought was, 95 acres, it's really 100 acres, but a lot of it is covered by the, surrounding roads. And, the property extends into the road. And then also, what's important about the survey is, on the survey, you want any and all improvements, which could be roads, which could be buildings, which could be all kind of wells. A lot of times, water wells get overlooked, and that has value. And you also want any and all easements on that survey, because this is what the commissioners are going to take, along with a lot of other information from the parties, and make their decisions. So you want them to have good, correct information. If they're going off of an old, 1970 survey or something that's just kind of drawn, on the back of a napkin, that's not going to work very well. So having the surveyor appointed and a survey prepared before the commissioners even really look at the partition is critical. And then the special instructions. And this is where, you learn as you go. And I've learned, a client asked me a really good question. Well, how exactly does this work? Are the commissioners going to go out to the property? Are they going to look at it? Are they going to meet with us? What's the procedure? Not in here. Not in the other book either. And so you look at case law, and surprisingly, there's some case law out of Harris County that says, the commissioners, they didn't go visit the property, but that's okay. They don't need to even do that. And so if you're representing a landowner and the commissioners don't even go look at the property, I think you're going to have a landowner that's going to be shaking their head going, what's going on here? So, and I know I would have. And so, because the landowner wanted to go with the commissioners to point out the unique attributes and characteristics of the property. And so you want to build all those special instructions in the order. In other words, saying, yes, this land can be partitioned. Yes, these are the commissioners, these three people. Yes, this is the surveyor. And then, yes, commissioners, you need to do this. Go look at the property. And really, I mean, it's up to whatever the judge will agree. A lot of times, the parties will agree to these things, but if not, I mean, this is what you ask the court to instruct the special commissioners to do. So important, and also, like I said, to take into consideration all these different things when they're dividing value. And I guess let me kind of focus on that for just a second. Is when the commissioners, and when we go into the and we were talking about the commissioner's part, visiting the property, meeting with landowners, reviewing appraisals. This also formal and informal hearings and meetings. I've done them multiple different ways. I've had multiple special commissioner meetings where the special commissioners would meet with one side and then meet with the other, and then meet with the other side, meet with the other, and say, submit your information. And then I've also had one where, actually here in this building, where 3 commissioners took about an hour, and each side put on their evidence, and that was the hearing.
Who gets to pick the special commissioners?
So one thing about the special commissioners phase and evaluation is, or you may say, well, who gets to pick the special commissioners? Well, if the two parties can agree on special commissioners, that's one way. If not, then the judge oftentimes will say, well, give me some suggestions and then I'll pick them. But ultimately, the judge will. I've done it recently where, obviously we picked one, they picked one, and then the judge picked one. But on this commissioner's phase and dividing it, always remember that in a partition, it's on value. People almost always will oftentimes say, well, it's 100 acres, it's 4 of us, and we all each get, 1/4, that's 25, 25, 25. But my 25 just happens to be on I-10. Sorry, and yours is way in the back in the floodplain. No, it's on value. And so that begins to get obviously a lot more complicated. And that's where it's important to have appraisals, and we'll talk about kind of appraisal methodologies. But so always remember it's value, 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 and not, you have someone come in, they own 1/4 of 100 acres, and they say, well, I want my 25 acres. I own 25 acres of this. No, you don't own 25 acres. You own 1/4 of 100 acres. All right, so you get the commissioner's report, and then is that it? Is that the end-all, be-all? Maybe, maybe not. If everybody's happy with the special commissioner's report, then that's it. If there's no objection, final judgment, it's a done deal. But how often is everybody happy, right? And so normally, or who knows? But yes, if you're not happy with it, you can object. And you can object and say that it was not a fair partition, or that it didn't comply with the order, which is a lot of these special instructions possibly. And I've done it both ways. I've actually had one recently. It was nice where nobody objected to the report. And I've also had commissioners let both lawyers know we are thinking about doing A or B. And it's like, A is not great for us, and B is great for us. So hey, we're sitting pretty good. We're in a good situation. And then they do C, and C is not what we want. And so I think sometimes it would be helpful if special commissioners would say, we're thinking about doing A or B, but why don't you all go and try to work things out? Because with partitions, and we'll talk about mediations, I think the best result is normally when you reach a mediated settlement agreement, because the parties know the land better than anybody else. So,
can you be appointed as a special commissioner?
So the commissioner, I've asked the courts, I've asked one or both of these judges that I would love to be a commissioner on partition cases, and they laugh and go, well, but you're normally the one with the partition case. So no, so normally it's not county commissioners, obviously. It's people that are landowners in the community or they're in the county that normally are knowledgeable about land and real estate. So who is that? Realtors. If it's farmland, then you'll get some sophisticated farmer that has lots of land and manages farmland. And, what you run across with these partitions a lot of times is, you do have a lot of moving parts. You may have land in 3 different counties. It may be a ranch. This particular property is where we do X for the ranch. How are we going to do that if I don't get it? You know, because we're all still in the ranching business, and so you have a lot of moving parts, and you need people that will understand that. You know, and if it's irrigated or not, or you know, all those things. Yeah, the courts will normally say, as always, you know, if you all have an agreed order on the first trial, great, hand it to me, sign it. I've done that. Other times, you know, no one can agree on anything, and so you actually have the first trial, and I've done that, right? And where the court will appoint the commissioners. Also, I've had it where the judge has said, you know, you submit 3 names, and then I'll pick 3, you know, something like that. So, but yeah, I mean, this process, you always have to remember, you know, most of the time it's family members. And a lot of the disagreements go back to things that don't even relate to land, right? But they're fighting about land now, or it's gotten so diluted with so many people. I mean, you know, I had a partition. Luckily, it was 3 people, and they were all in their 80s, and they said, well, really, 2 of them didn't want a partition. The other one did. That was my client, and they said, look, because he said, I really want to get this wrapped up. If not, it's not going to be 3 people. It's going to be, you know, 24 people. And that was a concern. I've always said I would look into the history of this, and I haven't. I just, because, you know, I spend all my free time doing other stuff, but no. So, no, but just like the history of the commissioners for condemnation. So it's very similar, right? I mean, it is, you know, condemnation, eminent domain. You appoint 3 people to be special commissioners to come up with valuation. And the answer is, well, why? Why do they do that? Because, you know, if you don't like their answer, you can object, and then it goes into normal civil litigation. So kind of similar to this, but where does that come from? And I will look into history, but I think the history will say a long time ago it was these 3 people made the decision, and that was kind of it. Yeah, and I think it was, well, let's, instead of having a jury of 6 people or 12 people, let's just keep it simple and have a jury of 3. I think that was kind of probably the rationale. But I do want to know the history of it, because it is different than any other proceedings that we have, except eminent domain. So, but the great thing is, you know, normally you've got people that are understanding land and the complexities and the valuations, and that gives, you know, landowners a little bit of comfort that they understand where we're coming from, and they're listening, and it's a little bit more of an informal process, and they felt like you want your client to be heard, you know, on the really complex ones where, you know, my clients just kind of said, this is the only way it can be. I just, you know, what do you want in any trial? You want to be able to put on all the evidence and do, you know, and at the end of the day, you've done the best you could, and that's what I did in that case. Is just get it all out there, and hopefully that they don't miss anything, you know, and then they make a reasonable decision. And when you get something out of left field, like I told you before, you know, A, B, and then they do C, that kind of threw everybody off everybody. And so what happened in that case? We actually went to another mediation. In partition cases, it's not uncommon to go to more than 1 mediation. I've had 2 mediations. I've had 3 mediations. I've had a mediation where I asked Randy, you know, suggest someone that a mediator. That's the other key thing, is get a mediator that understands partitions. And we used a lawyer that wasn't a mediator at all, but he was the one involved with the Duncan partition. And so he informed everybody real well how long this could go on. So, and complicated. So, you know, representing co-owners. Well, this is kind of the ethics part of it. You know, you want them all to be aligned. You can't have them halfway through the partition, all of a sudden someone changing their mind and saying, but I really want this, and no, but then you've got, you know, next thing you know, you have, you know, clients fighting over the same property, or wanting to be, you know, jettisoned out of your group. So be careful with that. Always have these, you know, conflicts of waiver. But really what they say is, in the event that you all don't want this same objective, then I'm out. I mean, I'm out for everybody. So, and then always, yeah, be prepared to withdraw if you have to. What I always have to emphasize is, first trial, okay, commissioners do their thing. Commissioners report. And if we don't like it, someone can object, okay, and then you have the second trial. and this is what a lot of people they just think this. Well, you know, the judge will fix it. The judge will fix the report. If it's not the way we want, well, we can convince the judge to do this or that, or the other thing, or a jury. Well, no, it's kind of a is it or is it not fair partition, or did they comply with the order? And if the answer is no, what happens? Oh, well, send it back to the three. No, scrap that panel, appoint 3 new people, and start over. And so I always have to kind of use this motion of you can just kind of keep doing this for a while. And of course, okay, if the second trial it is found to be a fair partition, and they complied with the order, then of course then you've got the you can appeal to the Court of Appeals. So there's lots of different ways to kind of keep this thing going. So
What about fees? How are fees divided between the co-owners?
they let's just say there's 5 people. They represent 4 and I represent 1. Okay, and they go, well, judge, divide the cost 50-50. Of course they're going to ask that, but I mean the case law is really clear that no, it's a pro rata division. So my guy doesn't have to pay 50%. He only pays whatever 1/4 or 1/5, whatever, if it's 5 people. So remember that on the whole pro rata appraisals. This 23A. The court appoints an appraiser to appraise the whole property, 100 acres, and I sometimes don't see a big value in that or use for that, but that's what now the parties can agree. Hey, we agree to waive that, or we agree that for purposes of 23A, that particular section, we're just going to use the CAD value. I asked you to do that one time in a partition case, Randy, and of course the other side said no, let's not do that, and so no problem, but it would have been a cheaper way to not pay $5,000 or something. But that's going to happen. So one way to we're doing this on another case right now is the appraiser that appraised in that stage the whole property. Each side has agreed he can now appraise kind of portions and a proposed partition for each side. So that's one way to handle appraisals to try to save money. But potentially you could have one appraiser appointed by the court, one appraiser appointed by one side or hired by one other side, and a completely different appraiser for another side. Or, and that's if you just got 2 different sides. If you got 3 sides or 4 different sides, you could have 4 different appraisers. Now, we've agreed one time, okay, we're going to use this particular appraiser. And we're going to, and we're talking about, let's say, 3,000 acres. They think that 3,000 acres can be divided in 6 different particular tracts. And we think, no, it should be 12 different particular tracts. And if you divided it in 6 tracts, it's got one value. If you divided it up in 12 different tracts, it's got a different value. So that's important. And so we actually agreed the appraiser's going to do his valuation with 6 tracts, with 12, and then we'll go to mediation. And, but it's all about, determining, I'm going to meet with a client today, and I want him to tell me, tell me the shape that you want out of this whole tract. And, our appraiser will tell us more or less how many acres it will be, according to value. So with the appraisals, it's really important to get it. So many clients will, before they even go see a lawyer, well, I already got it appraised. Well, they got the whole property appraised. That doesn't do you any good in a partition case, because you've got to value out your part that you want versus what the other side will be getting. Mediation, go to mediation with all the tools you need. What are the tools? You're going to be at mediation if you've got 100 acres and your guy wants, it's the 1/4, 3/4 scenario, but it's real unique, and he wants this. You got to have some way to draw it out and get estimates on acres, because all of a sudden people are going to, and we had this, Ashley Tegler and I, people wanted to start saying, well, okay, you want 30 acres, but we'll agree to give you 28 acres. well, no, we want 20, and undoubtedly your client's going to say, what does that look like? What does that look like on a map? So you need an aerial, you need to be able to, and normally the CAD maps are real good that where you can draw and measure and estimate and things like that. But you need to be able to do that at a mediation and frankly have a way to print it out, because if you reach an agreement, your agreement needs to say, the parties agree to, Hundl's client's going to get 28 acres that will look like this shape on Exhibit A or B or whatever. So that's critical. And then, the ability to describe the partition. So it's not going to be surveyed. There's no way to have it surveyed before the mediation or at the mediation. You've got to do it post mediation. So, and then agree on all the little miscellaneous things that, a lot of times, these tracts of land, farmland, ranching, whatever, they want to be fenced, and everybody agrees they're going to be fenced. Well, who's going to fence it? Whose person's going to fence it? What's the cost? What's this? The surveyor, agree on the survey, agree on all that. But then also, I like including, I don't like arbitration really. I was told when I was at Fulbright and Jaworski, never include an arbitration provision in any kind of deal. But in mediation agreements with partitions, I like having an arbitration provision that the mediator will serve as the arbitrator, because the mediator will have spent a whole day with these folks and all of the issues and the land. And if there's some little minor disagreements about whatever, normally the mediator does a real good job as an arbitrator. And then the final docs, this is just, wrapping it up. Either, I've seen it done two different ways. Final judgment and a dismissal. You get the partition deed signed and make sure, the partition deeds have what they need in them. If it's easements to get to this tract, then make sure you've got the easement described. We had a dispute over how wide the easement was going to be. Well, it was going to be where the existing road is. Was it 30 feet wide? Is it 28 feet wide? I mean, really, is it that big of a deal? Well, it was to somebody. So that was something we had to have arbitrated. Maybe it's up to the title company. I don't know. I guess they would prefer deeds, I guess. But and then, getting the commissioners paid and the surveyor paid. That's a problem sometimes. Clients are they spent way more than they anticipated. They're done. They're fed up. Make sure that the commissioners get paid and the surveyor gets paid, frankly, even if it comes out of your pocket, and then just chase your client down. But you don't want the commissioners to get stood. So, and I know that's happened some, and so. I think that's it. Probably any questions? Y'all have asked a lot of questions as we went, which was good. So,
What would be a short time frame for a partition?
a 2-year partition's about right. By the time, because if you're going to be getting appraisers and things, those appraisers they just take a long time, because once again it's not valuing the whole, but it's valuing your proposed partition and how it equates, and it needs to equal in value. There's I don't there's a lot of other things I can say about the procedural part, but it's not necessary. If you're doing the 23A, read like Judge Sklar would say, just read the law, and follow the rules, So, I enjoyed it. It's interesting. It seems like partitions really picked up. I saw them pick up during COVID. I think people sat around and started thinking about, the undivided interest they owned in land, and it wasn't really doing anything for them. And I don't know if they wanted to turn around and buy some of the land, but I saw a huge uptick in partitions when COVID happened, and since then there's been lots of partition movement. So,
How can a partition case become cost prohibitive?
I mean, what if there's all these people you do know? There's 20 people that you in fact do know where they are, and you've got to serve them, and you've got to. I mean, that in and of itself is cost prohibitive. That's why partitions, when it's a smaller partition of property, I don't know many people that want to touch it. Lawyers, because people aren't prepared to pay what's required to do it. Like I said, a 10-acre partition essentially could be the same as a 1,000-acre partition, cost-wise.